Ladies and gentlemen, we will call this meeting of the Juvenile Justice Committee to order. We have a couple of measures before us today, so Chairman Administration, we will go with the agenda and start with House Bill 1068, and if you will, just confirm the LC number we're working on, please, sir.
Yes, sir. Both bills are... That's all right. Thank you, Mr. Chairman, members of the committee. Both bills are as introduced. So House Bill 1068 is LC 480185. So just to briefly provide a bit of background. So last year, Governor Kemp signed the Equitable Caregiver Act, which placed Georgia on par with many other states that really allows judges to determine custody issues based upon what the child has previously experienced as an individual who has filled that parental type role, not so much in the rigorous relationship context that we previously had for third-party custody before this law was enacted. So just to kind of give you a summary here, we're only talking about circumstances where a parent is found to be unfit, both parents are unable to care for the child. And under law prior to this act, a judge could hear what we call a third-party custody action from only a set group of family members. So it's great-grandparents, grandparents, aunts, uncles, cousins, siblings. I believe that's it. So, and our friends here can advise if I'm off on that. But the point of this was to allow for specific circumstances if a non-family member had really filled that role of like a parent, to allow judges to consider in those limited circumstances, which really should be pretty rare that this occurs, but to ensure that was available for judicial consideration. So, and I was very proud of the partnership that we had with Representative Reeves, who worked on a lot on this as a floor leader. He worked on it last year, and many others who were participating in this. So part of the plan also was to include a form in the statute to make it easier for Georgians to utilize this statute. And so what I have before you here, sorry, that's a long-winded way of saying this is a cleanup bill, effectively, along those lines that has been brought. And so I'll just briefly go through. First of all, there's the changes you'll see. A lot of this language is from last year, but on the bottom of page 2, that's just cleanup language to make some of this clear. And then top of page 3, so lines 59 to 61, the form actually missed one of the criteria that we had in the law. So this just corrects this statutory form to follow what the law says. All right. And same thing on line 67. It just allows for an additional blank to fill in for those circumstances so that the form matches the law. Okay. The operative language then, if I go to lines 97 and 98, so I have received some feedback that there was an unlimited look back in the existing statute. So you could go back to anybody who had served in that parent type role at any time in the past. And the concern was that's too broad. So what we've done here is try to limit it to the past 5 years, okay? And the recommendation originally was 2, and I picked 5. And if the committee has strong feelings on that, I'm not, we're the policymakers here. But I felt like 5 was adequate enough to get recent, history for a child and to allow the court enough discretion to do what needs to be done. So that's how we came to that. All right, then. Lines 127 to 129 and I'm very grateful to Chairman Ballinger for allowing me to have this hearing today. I'm grateful to you, Mr. Chairman, for the opportunity to be here. But Chairman Ballinger and I have had many discussions about the potential for unintended consequences, use of this statute by somebody who maybe has perpetrated family violence or has been an aggressor in a violent manner or something in a relationship, like maybe somebody who's lived with the parent of a child and has been removed from that parent's life because of domestic violence, and then would try to use this as a means to terrorize their former partner. And so we want to make it clear it cannot be utilized by anybody who has been the subject of a family violence protective order or has been convicted of family violence. And so I will just tell you, if there's any issue with the language here, I know we're close to crossover day. I commit to y'all continue to work on that to clean that up. But that's the intent that we're really after. All right, and then finally in lines 139 to 142, I really get to the heart of some of the questions that we got on this issue before. And by the way, I think this language is important to protect this from judicial challenge in the future. And that is, If a parent ultimately becomes fit, so let's say there's, in a hypothetical, a parent suffers from substance abuse, okay, or both parents do, all right, or unable to care for the child. And the judge says, okay, having heard this, I've now determined that this other person who was previously filled in that parent-type role should be designated as an equitable caregiver and receive custody of the child. Then later in time, if that parent becomes rehabilitated and is then able to care for the child, then the equitable caregiver status would no longer apply. The reason for this is that there's a potential constitutional challenge because of a parent's rights to that child, and we want to make sure that this statute continues to be in place well into the future. And so out of an abundance of caution, we are including that, and the experts in this field have said this will help to really shore up the law. And so would appreciate your consideration. Be happy to answer any questions.
And for the committee, I want to take questions for Chairman Estration, but in my move to get us started in a timely manner, I forgot to inform everyone that there's a sign-up sheet. So we will, on any measures today, we will just ask if anyone's here to speak to the bill. So please know if you're here for that purpose, I will recognize you after questions for Chairman Estration. So number 23.
Thank you, Mr. Chairman. Chairman Estration, on the thing you were just talking about, lines 139 through 142 for a layperson like myself, how does so a parent now is eligible to have custody restored? How does that process work? Does a judge make that decision as to whether that's the best place for the child now?
Yes, sir. So there's a few different ways it would occur, but what we're talking about here is a custody decision, which is made in Georgia by a judge in Superior Court. That's how that happens. And so just to give a hypothetical here, okay, let's say that there is an aunt who had maybe been helping to raise a child, had been involved in the child's life. Maybe that's a bad example because they would be captured under an existing third-party custody. But let's say maybe there is a step-parent, okay, who had helped to raise a child and the parties had become separated, and the biological parent, let's say the father is out of the picture, nobody knows where the father is, and the mother is suffering from an opioid addiction, all right? The step-parent, step-parent who has a relationship with the child's previous, there's all these factors we have to go through, was not for money, has the child, anyway, my point is that person would then be awarded custody under the statute, all right? Then the mother becomes rehabilitated in this example. The mother would then petition back with the court to terminate the equitable caregiver status, and a judge would make that consideration because of the constitutional right of parents under the U.S. Constitution.
Follow up, Mr. Chair. But is the best interest of the child still the criteria?
So, no, sir. The criteria is the parent going to cause harm to the child?
Yeah. So theoretically, a child could be in the custody of this third party for a decade. Let's say from age 2 to 12. The parent now is eligible for custody. They've solved whatever this issue was, and they petition the court for custody of this child who's been in this other person's custody for 10 years. And the judge is not allowed to consider the best interest of the child at that point?
So I take your point, and what I'm doing is parroting my understanding of what the case law challenges would be to the circumstance, but probably an argument for that custodian, that equitable custodian would be, this will cause long-term emotional harm to the child to be returned to that parent, and therefore
so we're still
that should
safe.
Not be
Okay.
upset. And I will say this law does require that judges write their orders very carefully to conform to the law and the case law in this area, and that's why I'm back this year to try to make sure that
Fair enough.
that it survives.
Thank you.
And so I want to interject there to make sure I understood that very last point that you're making. So in the situation you gave, stepdad, mother is rehabilitated, mother comes back into the picture. You're telling me that it's not a given that the mother would be awarded custody, that there is a Go ahead.
So it is a given unless the step-parent can show that the mother will cause physical harm or long-term emotional harm to the child.
Okay. Number 16, Representative Hutchinson.
Thank you, Mr. Chair. I would just to be devil's advocate, I would say if that wasn't the case, if the judge would automatically take the child's, it just sounds like termination of parental rights if you don't give the mother or the biological parent a given that it's their child, their rights have not been terminated, and if they're rehabilitated, they would get first choice.
Number 1, is that Representative Sharper?
Thank you, Chairman. In looking at this, and this is far-fetched maybe, but let's just say in his example that the kid's been in the custody since 2. Let's just say by age 8, where it looks like, you know, I'm going to have this kid, what will stop that parent, well, the new custodial person, what will stop them from adopting that child?
So adoption would be a separate proceeding that could occur, and that would just be a separate analysis. This is separate and apart from adoption, dependency cases, other avenues, guardianships. There's other avenues for a similar outcome. This is different.
Okay,
yes,
because
sir.
the guardianship was going to be the next thing, but okay, I'm just making sure that's totally clear.
Seeing no other questions from the committee, is there anyone here who would like to speak to the bill? Seeing none, what is the will of the committee? Number 22.
Mr. Chairman, at this time, I'd like to make a motion to do pass House Bill 1068, LC 480185.
There is a motion do pass and a second that House Bill 1068 LC 480185 do pass this committee. Is there any further discussion? Representative Lott.
I have a question. I'm sorry for the author. I should have asked a second ago, but where is this coming from? Was there already a demonstrated problem, and that's where we're making corrections?
So yes, there was, going back several years. Each year we had, you might remember Representative Beskin had a step-parent custody bill. There were multiple bills. We had, I had a de facto custodian bill that I worked on for 2 years. That's a previous iteration of this, and so there's certainly a problem that's out there. I'm happy to detail that further. This bill itself is just from me and my communication with what's my collection of comments that have been made to me over the past year since this was passed.
Has anybody requested this? Or I know you just said it's just from you, but I mean, this must have come from something. Did it come from something specific, or did we have problems in the system?
I'm just trying to answer your question directly. I can tell, like, the form I noticed right after it was passed, I was like, we got a problem with the form because it doesn't conform to the law. So that was out of my head. There is an attorney who has, he might be here today, who's requested the look back provision, and he's communicated with me multiple times about that, and that's from a personal case, I believe, that he's in. Chairman Ballinger raised the issue of domestic violence, and that was, I think, an important point that was raised last year, and so I remembered her comment about that. And then 139 to 142 is my understanding of the case law and concern for these issues, and I think it's fine to mention I've also, I've worked with the Barton Center and Professor Carter to work on this potential language and I think the general belief is that this will shore up the existing law. Does that answer your question?
Yeah, thank you. Appreciate it.
Representative on number 1.
Yeah, I think one of the best examples that you could, use with this is when you have a case of a godparent that we see a lot of times that's been taking care of the child, doing what they need to do for the child. Now, second little question, we could probably talk about this later, but if you have a godparent, and let's say you have a grandparent, aunt, uncle, all that, will you have to go through the process of seeing if they are better fit or want the child over the godparent, or will that godparent have the same equal opportunity, if you will? What do you think about that?
I'm sorry, I'm not sure I followed. Is it between a parent and the godparent?
No,
Between
we've already
two-
established that either one of the parents
Yes,
aren't fit. But now you have a grandparent or aunt, but the godparent is just as strong of whether to take care of the child and do
Great
things.
question. So they'd be on equal footing effectively
Okay.
to contest for a third-party custody petition.
Awesome. Okay. Yeah.
Does that answer your question,
Yeah,
Representative Sharp?
But
Okay.
I'll just say one final thing. These the factors the elements that must be proven, I think, are really extensive. It's hard to get classified in this way, and that was done intentionally to make sure there was not too broad of capture of people who could be considered by the court. Thank you.
There is a motion and a second on the table. Do pass. All those in favor will say aye. All those opposed, same sign. Motion carries. Okay. Don't go too far, Chairman Administration. We'll go back to House Bill 1074. Once again, if you will, confirm the LC number, and for members of the audience, once again, after questioning of Chairman Administration, if there is any, we'll ask if there's anyone here to speak to the bill.
Thank you, Mr. Chairman. So this is House Bill 1074 is introduced to LC 289673. So, Mr. Chairman, I have had an interest in being supportive to the Division of Family and Children's Services throughout the past few years, and I've carried several bills to assist with potential updates to the code. And so my view is that really an initial step here as we work to support Governor Kemp's outstanding efforts to make Georgia the #1 state for foster kids is to really make sure that we continue to receive the data that's coming in as far as what applications are made. I know that Representative Hutchinson's done a great job of profiling foster children and the need. But I guess my question is if Loving Family says we want to become foster parents and they have an interaction with the state of Georgia attempting to initiate that process, how are those cases? What's the ultimate disposition of that application? Where does that ultimately head? And interactions with private agencies, with the department itself, and I think allocating resources to most effectively actually help kids is going to be an important consideration for the General Assembly in the future. So I really view this as year one of an effort to just be very supportive of the efforts that are being made and to work in concert with the governor's office and other leaders in the state to make Georgia really a shining example of how to utilize loving families who want to become foster families. I've met with Director Rollins today, and he has provided some great language. I will say we serve on the Justice for Children Commission with the Supreme Court, and I really am grateful for Director Rollins' leadership and hard work, and just so proud to see his efforts on behalf of Georgia's kids. And I really actually like the language a lot that he's provided to me here, and so. What maybe I could do is, if it's all right, I could make copies to hand this around or allow him to address it. But I would be happy to maybe seek a substitute that would incorporate this language in, and it has the same impact, same policy purpose of the bill as introduced, but would just allow for data collection so that we can see ultimate dispositions of cases. Thank you.
If you want to walk us through that potential change and maybe the direction that you think we should go, and I understand there are members with questions, but since we're discussing a potential change, if you will indulge me, I'd love to hear the changes before we go down another rabbit hole.
Yes, sir. Thank you. So first of all, it's in section 49-5-4.2. This is for child placing agencies to provide statistics on recruitment and retention of foster parents. So the child placing agencies would provide to the Division of Family and Children's Services of the Department quarterly statistics as to the number of foster families currently approved, licensed, or certified by the agency. And that also includes their county of residence, the capacity of the fostered home, and the types of children for whom the home is approved. and the number of foster parents who have submitted applications to the agency to serve as foster parents during the quarter, so it's quarterly, and the outcome of such applications. And that the division shall publish the data on its website and shall update the published data each 6 months at a minimum. My thinking here is, well, I'm sorry, I'll go ahead and finish this. And then for 49-2-6.1, which would replace what's here in the bill, it's that the division would compile quarterly the statistics of the number of foster families approved, licensed, or certified by the division. That includes the county of residence, the capacity of their foster home, and the types of children for whom the home is approved, and the number of foster parents who submitted application to the division to serve as foster parents, and the outcome of those applications. So that could be approved, it could be denied, it could be referred to a private agency, could be, that's pretty much it. And pending, right? So that'd be pretty much it. But and then the division would publish the data on its public website, so any member of the public could get that. And I'm very grateful for our leadership, and I think that into the future, this data, that accumulation of this data, and making this public is a good transparency measure to just show the effectiveness of the work that's being done. And frankly, I think it's important to know the counties where there are issues, and to allow for maybe a more direct approach at certain locations that would be both beneficial to the division, but also beneficial to Georgians and the communities. Communities want to be supportive of the division and kids local to the community. And so I think that would be a real strong message to send. So thank you.
Okay, all right. I know there's a couple of moving parts here, so I want to answer any questions that we have from the committee. I was going to say, Director Rawlings, if you'll join us prospectively for answering questions, and then to the members of the committee, if we're going to move forward with potential language changes, we will break so that we can get those changes in front of you for review. But if everyone understands the language that we're discussing, and at this time you want to ask questions, I'm happy to entertain those. So Representative Hutchinson.
Thank you. This doesn't exist somewhere already? I feel like y'all put out a lot of data already.
Not enough. So what I tell people all the time, there's never enough data. So I really appreciate Chairman Administration bringing this issue. We wanted to kind of make sure that we have all of the flows. So foster care applications flow in directly to CPAs, and they flow in through our agency. We want to make sure we're capturing all of that. What we often see in the media, for example, is that there are not enough foster homes. That's not just the issue. The issue is, where are those foster homes? What is their capacity? What kind of children are they able to take in? Because we want these children close to their communities of origin. So the more we know about what counties the homes are in and what kind of homes we need in that county, the better off we are. The other thing that I know Chairman Administration was trying to get at is, and what I hear from foster parents all the time, is that this process takes too long sometimes. So if we know on a quarterly basis how many applications we've received, how quickly we have disposed of those applications, whether we've done it well or not, then that gives us an incentive as well as the CPAs to get these things moving and get people approved.
Well, I can just tell you, when I read it, I didn't like it because it feels like we're giving the department another job the day after we voted on a budget to take 200 positions away from you.
I appreciate that, but trust me, this is data I want. We cannot do this job without having really good data on foster homes and foster children. We have to know where we need it. I'll give you a good example. I got a call from a county the other day that said, do you know we only have such and such number of foster homes in this county, but we have all these children in foster care? And I said, honestly, I did not know that. Thank you for letting me know. So this kind of legislation will spur us to do a much better job of tracking that, and I really appreciate it.
And the Child Advocate's Office doesn't have this?
They're the Child Advocate's in D.C. right now. I can call her and ask her. But I know that she and I have discussed the very issue we're talking about here. Even before we saw this bill, this has been an issue that has been ongoing. And it's an issue I've discussed with many CPAs, with our foster recruitment folks, with everybody. So this is good policy.
Mr. Chairman, we have the substitute. If we could please pass it out.
And real quick, would you give a copy of that to Legislative Counsel for her to review just momentarily to make sure we're
Yes, sir.
while we entertain some other questions. Representative Lott.
I was going to ask some similar questions that Representative Hutchinson just asked. So this is not done through rules and regs?
I'm sorry?
You can't, this is not a rules and regs sort of, this has to go through code to where we insist upon a quarterly?
I think this is the way we should probably do it. It clarifies what we're supposed to do. This actually fits in. If you look at the code sections that we're amending, they already require certain things, and I think especially with regard to the CPAs, if we're putting the CPA requirements the same as the DFACS requirements, and that way everybody knows what their job is, everybody knows what their duties are. This does not get lost in an administrative rule, and so it actually gets done.
Okay, I appreciate your answer. Thank you.
Representative Dickerson.
Chairman, so on line 14, you will now be changing that from an annual report now to a quarterly report in terms of the reporting?
Right, it's actually going to be more frequent. So we get the reports quarterly. We publish them at least semi-annually, but I would imagine we'll update it on, my goal would be to update it on a regular basis. At one point, I actually created a map of all the foster homes in Georgia. That's a little harder to do because it gives away too much information, too much detail, because you don't want to know exactly where the foster homes are. But this is the kind of thing where we can use to work with all of our foster care recruiting.
Thank you.
Thank you. Seeing no other questions from the committee, I'd just like to recess for 5 minutes, stand at ease, so that we can discuss with Legislative Council and make sure that everyone on the committee's had time to review. So take a short break. We will come back to order and let me explain the posture that we're in. Has everyone had time to review this language in front of you? Are there any further questions for the chairman as the language in front of you? I'm going to entertain a motion, and Chairman Estration is going to explain that this language will become an amendment to his bill. So I just don't want anybody to think that we're jumbling this up, so that we're all on the same page. Chair recognizes Chairman Estration.
Thank you, Mr. Chairman. I move due pass on House Bill 1074 with the understanding I will offer an amendment in just a moment if it's seconded.
There is a motion. Is there a second? There is a second. Is there any discussion? Chair recognizes that Chairman Estration.
Thank you, Mr. Chairman. I have an amendment, Mr. Chairman, to remove lines 9 through 19 of the bill as introduced and replace it with the language that's provided on the handout with one amendment to that amendment, or just one addition here. And it's on the third line of text after child placing to add agency. And so that's my amendment, Mr. Chairman. If there's a second, I would be happy to.
There is a motion to accept the amendment and a second. Is there any further discussion on the amendment? Seeing none, we have a motion and a second. Do pass House Bill 1074. Sorry, we'll vote on the amendment. All those in favor of the amendment say aye.
Aye.
Any opposed? Thank you. The amendment's adopted. Chairman Estration, I understand that you've authorized Legislative Council to make these updates and to renumber this bill as necessary.
Thank you, Mr. Chairman. I forgot to mention, Legislative Council, I'd ask unless there's any objection from the committee, Legislative Council be authorized to renumber and re-letter as necessary to fit this into the code.
Seeing no objection. Okay, there's a motion and a second on the floor. All those in favor, please say aye.
Aye.
Any opposed? Motion carries. Ladies and gentlemen, I'm sorry to do this to you, but I need you to stand by for a couple more minutes. There is a possible addition to the agenda that I'm trying to confirm right now, so I promise I won't keep you long, but if you'll give me just a couple of minutes to confirm that.